So, back in the 1970s, a young, ambitious entrepreneur and filmmaker sat down with Hollywood studio executives. He had a vision for a space opera. The studio didn't really get it, but they were willing to fund it. When it came time to negotiate his contract, the filmmaker did something that left the studio lawyers smirking behind his back. He reportedly accepted a massively reduced directing fee. In exchange, he asked for two things the studio thought were completely worthless: the sequel rights and the merchandising rights. At the time, Hollywood lawyers literally referred to these types of provisions as garbage clauses. They were considered administrative junk, thrown into a contract to make a creator feel good, while giving away zero real economic value. The studio thought they had won. The entrepreneur filmmaker walked away with less upfront cash, to be sure, and the lawyers went back to their expensive lunches. That filmmaker was George Lucas. The movie was Star Wars, and those garbage clauses didn't just build a multi-billion-dollar empire, they completely reshaped the economics of modern entertainment forever. If you're new here, hi, I'm Tristan, and this is Professor Punch. It's built by a team of entrepreneurs and legal professionals. For years, we help train staff and advisors around family offices and high net worth individuals. Welcome. George Lucas's deal is probably one of the most entertaining stories in business history, but it teaches a legal principle that every serious entrepreneur, creator, founder, and investor needs to etch into their brain. The most valuable part of a deal is not always the upfront cash payment. Sometimes it's the legal rights everyone else is completely ignoring. When you're negotiating a transaction, a partnership, a client contract, or an exit, amateurs will only ask one question: how much am I getting? A legally intelligent operator asks the much more important question: what am I giving away forever? To understand what happened with Star Wars, you have to understand the Hollywood mindset of the mid-1970s. Before Star Wars, movie merchandise wasn't an industry. It was a cheap promotional afterthought. You made a movie, maybe you printed a few t-shirts, maybe you printed some posters to get people into the theaters, and that was it. No one was building a fortune on action figures. And sequels? Sequels were seen as creative death sentences. If a movie did well, you might squeeze out a low-budget follow-up. But the idea of a cinematic universe or a multi-decade franchise did not exist. So when George Lucas offered to trade a lower upfront salary to keep the merchandising and sequel rights, 20th Century Fox looked at the spreadsheet and saw pure profit. They lowered their immediate cash exposure on a risky sci-fi project, and all they had to give up was garbage contract clauses. But the law doesn't look at assets based on current market popularity. The law looks at ownership and control. The studio, well, they saw a line item with zero historical value. And their lawyers, well, they saw an unencumbered permanent grant of intellectual property and future options, with little expected future value. When Star Wars became a global phenomenon, the cash flowing into the box office was massive, but the cash flowing into toy stores, licensing agreements, video games, clothing, and sequels was astronomical. These small clauses became the empire. Fox owned the film print of the first movie, but Lucas owned the future. Now, if you look at our previous case studies, the legal training angle is usually about avoiding a catastrophic mistake, but this story is different. This isn't about avoiding a trap. It's about possessing contract knowledge and legal understanding. Lucas didn't have a Harvard law degree, but he had a foundational understanding of the legal essentials and long-term asset control. He understood that the studio was thinking in quarters, while he was thinking in decades. When you sign a contract as a modern entrepreneur, whether it's an agency agreement, a software licensing deal, a joint venture, or an employment contract for a key employee, you're constantly interacting with clauses that feel like garbage or waste, IP assignment clauses, non-compete and non-solicit boundaries, data ownership provisions, future option rights and right of first refusal. They look like standard boilerplate text. Your eyes may glaze over and you'll think, let's just get the deal done so I can get paid. But a few years later, the market turns and your company explodes in value. Suddenly, the documents wake up and you realize that a tiny, standard-looking clause you ignored 5 years ago means someone else owns the IP to your most valuable asset. So, what should a modern digital entrepreneur take from George Lucas? Before you sign your next major agreement, stop looking exclusively at the revenue line and walk through this mental checklist. 1. Isolate the future value. What am I creating in this deal that could be worth 10x or 100x more in 5 years? Am I retaining the rights to that upside, or am I handing it over as a freebie? 2. Define the boundaries of control. If this project becomes a massive success, who owns the derivatives? Who owns the data, the spin-offs, the secondary channels, or the subproducts? 3. Audit the boilerplate. Never let a lawyer or counterparty tell you a clause is just standard admin. If it's in writing, it's legally binding, and it's on the map of who gets to do what when the music stops. Most entrepreneurs don't have a legal structure problem because they're careless, but nobody ever taught them how to look at legal engineering as an opportunity to explode real wealth. They focus entirely on the velocity of the cash coming in, while completely ignoring the structural leaks quietly giving away their long-term equity and value. If you're generating $10,000 a month or more online, this already matters. You're signing vendor agreements, platform terms, client contracts, and joint venture deals every single week. Do you actually know what you're giving away forever? To help you audit your own business before an expensive mistake hits, we created the Professor Punch Legal Risk Scorecard and Quiz. It'll analyze your current business setup, your contracts, and your asset protection. It takes less than 5 minutes. Learn exactly where your blind spots are before a bad transaction forces you to find out the hard way. Click the link below in the description to get your score. Go make your money. But for heaven's sake, make sure you learn how to keep it.